General's office, but much more interestingly, I was on that side of the table at the national finals way back in 1995. So it's still the highlight of my professional career.
Good afternoon, Washington. Congratulations as well. My name is Gus Chin. I'm a municipal judge for the city of Holiday in Utah. Look forward to our discussion this morning.
And I do too. My name's Andy Levy. I'm a trial lawyer from Baltimore, Maryland, and I also teach at the University of Maryland School of Law.
Can you please introduce yourselves and your teacher?
Hello, judges. My name is Matthew Wengreen, and my favorite Supreme Court case is Roper v. Simmons, as it protects minors from capital punishment.
Hello, my name is Leah Nestru. My favorite Supreme Court case is Loving Virginia, as it banned laws prohibiting interracial marriage.
Hello, my name is Loveleen Tripathi, and my favorite Supreme Court case is Graham v. Richardson, as it granted immigrant non-citizens access to the rights under the Equal Protection Clause.
Hello, my name is Jesse Grayson, and my favorite Supreme Court case is Obergefell v. Hodges for affirming the right to love and the right to marry throughout the United States. And on behalf of Unit 5, Tahoma High School, our advisor Gretchen Wolfgang, and the state of Washington, we thank you for judging us today.
Great, thank you. And if you're ready, I'll go ahead and read the question. Today we chose question number 2. Ninth juror says, the facts are supposed to determine the case. 10th juror, don't give me any of that. I'm sick and tired of facts. You can twist them any way you like. Know what I mean? 9th juror, that's exactly the point this gentleman, indicating the 3rd juror, has been making. Why are juries required to render a unanimous decision rather than a majority decision in most criminal cases? To what extent, if any, do jury trials ensure due process as stated in the Constitution and Bill of Rights? To what extent, if any, do jury trials reinforce founding principles? Whenever you're ready.
Trial by jury is a privilege of the highest and most beneficial nature and our most important guardian of both public and private liberty. British Justice William Blackstone.
Juries are required to render unanimous decisions in most criminal cases to ensure that all convictions are proven beyond reasonable doubt.
The standard of proof beyond reasonable doubt was established in Miles v. United States as a requirement for jury convictions. Unanimous juries more successfully protect the standard than split juries by requiring all members of the jury to voluntarily reach a singular verdict rather than only a majority.
In Reynolds v. Louisiana, the Supreme Court affirmed the importance of unanimity by requiring it in most criminal trials.
In the majority opinion, Justice Gorsuch stated the requirement of jury unanimity emerged in 14th century England was accepted as a vital right protected by the common law.
Prior to the decision in Ramos, the court relied upon the doctrine of stare decisis through the precedent established in Apodaca v. Oregon.
In Apodaca, involving 3 split jury convictions, the court found that non-unanimous verdicts do not violate an individual's 6th and 14th Amendment rights.
In Ramos, the court ultimately deemed that the reasoning in Apodaca was flawed and that the Oregon non-unanimous jury law had discriminatory effects that hindered the pursuit of convictions beyond reasonable doubt.
Unanimous jury decisions allow confidence in most criminal convictions and prevent unwarranted violations of personal liberties.
Jury trials have not ensured due process, but have instead relied upon evolving case law and legislation to combat harmful biases.
The 5th and 14th Amendments establish that no person shall be deprived of life, liberty, or property without due process of law.
When individual biases infiltrate judicial proceedings, due process is inherently threatened.
Though the Supreme Court affirmed the need for impartiality in jury trials through the case of Parker v. Gladden, historically, more government action has been needed to prevent invasive biases, often through the elimination of discriminatory jury practices.
In Bassett v. Kentucky, the striking of 4 black jurors through a peremptory challenge was determined to be a violation of Bassett's 6th and 14th Amendment rights.
This case barred racial discrimination in jury selection, further protecting due process for racial minorities.
More recently, in 2021, the Jury Non-Discrimination Act was introduced to Congress. If passed, this act would amend the Jury Selections and Services Act of 1968 to explicitly protect against jury discrimination on the basis of sexual orientation or gender identity in federal courts.
Though jury trials have not ensured due process, additional government action over time has limited the impact of intrusive biases on judicial proceedings.
Jury trials successfully reinforce the founding principles of acting as a check on the government and challenging tyrannical and unjust practices.
The institution of jury trials has long been accepted as a form of British common law, yet was often denied to American colonists.
The 1776 Declaration of Independence cites the deprivation of jury trials as justification for forcibly resisting the English rule.
This affirmation of the right to jury trials and its eventual establishment through Article 3, Section 2, and the Sixth Amendment of the Constitution reflects the Founding Fathers' opposition to tyranny and commitment to checking the government.
Jury trials themselves further prevent government injustices by allowing the accused to be judged by a group of peers who better reflect the ideals of their community.
For example, throughout the 1850s, Northern juries acquitted people charged under the Fugitive Slave Act in accordance with their own values. They'll be opposing the law and challenging the federal government through jury nullification.
The ability to implement the principles and beliefs of the community is essential to juries and reflects the founders' emphasis on the people challenging unjust practices.
In Duncan v. Louisiana, revolving around the denial of a jury request for a teenager's criminal trial, Justice White proclaimed that trial by jury in criminal cases is fundamental to the American scheme of justice.
The trial by jury is a powerful limitation on actions of a government in which people are emboldened to check unjust practices.
Juries as an institution are critical to American democracy and the pursuit of justice. Thank you.
Thank you. So you mentioned jury nullification and how it was used in trials involving the fugitive slave law. Do you think jury nullification is a proper use of the jury power? Is it good for our justice system?
I do not believe jury nullification is a proper use of the power that's allotted to juries. I agree with Justice Harlan's concurring or majority opinion in the case of Spark v. United States in saying that our rights and liberties are determined not by an irresponsible, but by a responsible tribunal, and that juries are to determine the evidence and fact of a case rather than to determine a law itself.
I would like to respectfully disagree with my colleague Jesse. James Madison argued that it is not only the juror's right, but his duty to find the verdict according to his or her own best judgment, understanding, and conscience. Looking back at the 1798 Alien and Sedition Act, where the citizenship requirements were raised from 5 years to 14 years, and the president gained the power to deport any aliens, juries practiced jury nullification under cases that were brought under this act, and they effectively brought justice to minorities.
Adding on to my colleague Lovleen, it is up to the juries have a right to perform this action of jury nullification. In the words of Chief Justice John Jay, the jury is not only to decide whether or not the defendant is guilty, but whether the law in itself is fair.
But doesn't that essentially open it up to lawlessness? I mean, we're allowing one juror to essentially pick and choose what laws should apply. And when it's used for good purposes, great. But what if it's used to acquit white people for murdering a black person? You know, like, is it really that door we want to open?
I respectfully disagree with my colleagues Loveleen and Aaliyah and agree that it does leave the door open. Looking at the case of Ed Johnson in Tennessee in 1906, and throughout the South in the post-Civil War era, they convicted him of rape, even though he had several alibis putting him away from the scene, and one alibi putting him, convicting him of the rape, even though that person would later confess to a false confession.
But what does that prove?
That proves the jury nullification and the process of jury decision can be used wrongfully, and they can choose to go against the law and promote lawless action.
So do you think, in its totality, do you think that more jurors would get the right result even if for the wrong reason than the opposite? I mean, given all of the sort of racism, misogyny, and homophobia that we see in the general population, doesn't that concern you that nullification would work in that direction?
I believe current standards that we have, especially under the Duren test and Duren v. Missouri, which established a three-pronged test of one, that a group needs to be a significant member, a distinct member of the community. Two, they need to be underproportionately represented in veneer. And three, they need to be systematically excluded. Applied today allows that we don't have all white juries, especially when there is a black person being accused of a murder, and allowing the more values and more interpretations of the law to be brought to the jury.
Additionally, adding on to my colleague, in this process of veneer or voir dire, where a juror is selected out of a general jury pool, one of the questions that is mainly asked is, will you adhere to the law and prove a verdict that is within that law? So this question in itself prevents this action of jury nullification, ensuring that the jurors are picked will conform to the law that is being decided in that trial.
If I may jump in terms of what you've discussed, an individual is entitled to a jury of his or her peers. Are you aware, or do you see any problems with the current system in the jury process in one having a true jury of one's peers?
I do see an issue with the current problem. Looking at cases like Lesmond Mitchell, when he committed a crime on the Navajo tribal region, and then the trial was moved to the Phoenix area because of worries about impartial juries, which had the area of only 2% of the population of the Phoenix area is of his original tribe, and his jury later had only one representative of his Navajo region, with others being excluded for being too fundamentalist of his Navajo origin. And this leads to people still not having a cross-section of their community because of the moving of tribes.
Additionally, while it is not explicitly stated within the Constitution to have a jury of our peers, whether like in the Sixth Amendment, we're just say we should have an impartial jury, it is seen dating back from the Magna Carta in 1215 that we should have a judgment by our peers. And there has been increasing difficulty with having a true jury of our peers. This can be seen in wealth gaps that prevent many jurors who are unfortunately many people of color from serving on juries, whether that be them not being able to take enough time off of work to perform on a jury.
Another problem is that someone may commit a crime that is so heinous that almost the entire community will disapprove of the person's actions, and therefore the person will not get a fair trial. One solution to this is moving the trial to a different location.
However, I will respectfully disagree with my colleague in saying that moving a trial to a different location can introduce a slew of different issues with selecting a jury pool. If you look at the case of Ahmaud Arbery, when the jury trial was exported to a different city, the population demographics drastically changed and was reflected in the jury selection, as it resulted in an all-white jury, even though this all-white jury still ended up convicting the individuals who had been responsible for the murder of Ahmaud Arbery. It still introduces a great concern of this idea of a jury by one's peers.
Should felons be allowed to serve on a jury?
Felons should be allowed to serve on a jury. In the book written 20 Million Angry Men, written by Mr. Villanelle, who was a former felon himself after being convicted of a DUI, there are several felons who are released from jail and then prevented from serving on a jury. And Mr. Villanelle himself was in Pennsylvania, and at the time, in Pennsylvania did not allow felons, no matter how long after being released from jail, to serve on a jury again. However, several studies have shown that felons do not have an increased bias, whether it be pro-defense or pro-prosecution, any more different than a law student would be slightly more pro-defense.
How about jurors under 18, particularly in the case of a young defendant?
In the case of McKeever v. Pennsylvania, it was established that juveniles do not get a jury of their peers, and I agree with the majority opinion as they cited Roper v. Simmons. And the reasoning behind this case of Roper v. Simmons is juveniles lack the sense of maturity as they are growing and developing their brains. And I don't believe that juveniles especially can have a trial of their peers, and youth and minors are not developed enough to be able to make concise decisions to put away people into jail.
I respectfully disagree with my colleague Matthew. I believe juveniles should be entitled to a jury trial by their peers. If we look in the case of Henry Galt, we see that juveniles still possess some due process rights. However, I believe that jury trials should be included in this because even though they might be a younger demographic, they should still be entitled to this pivotal idea of being able to have the ability to defend oneself. And there are pivotal differences between only having a judge decide your case compared to a jury.
I want to shift gears a little bit and talk about jury deliberations. Under most circumstances, jury deliberations are secret. We don't know what's discussed in that room. Do you agree with that policy, or do you think that jury deliberations should be subject to review or public disclosure?
I believe jury deliberations should be kept secret, as I believe this ensures the idea of impartial jury. If we were to have jury deliberations be made public, this could introduce some concerns in the idea of some kind of outside factor influencing their opinions or their decisions, and can ultimately sway the jury to make sure that they are no longer impartial.
I believe that this also is required to protect the anonymous aspects of juries and having a cross-section of the community, because if the media were allowed to understand and be able to dissect the verdict by the juries, they may be subject to societal change and societal pressure and regret by the victim and the accused, people that disagree with what they rule.
But what if it's clear in the jury room that a particular juror is biased in some way against the defendant, or is being bribed by the prosecutor, or who knows what? Shouldn't the defendant, doesn't due process require that we know that?
No, but I would look towards Blackstone's formula that he says it is better that 10 guilty men walk free than one innocent man go guilty. And if there is a biased juror or a bribed juror, we look at in the ruling of Ramos v. Louisiana that there will be a hung jury if the rest of the jury disagrees with them. And I believe that this situation is okay to have a retrial and have the next jury, well, hopefully one of them will not be bribed to ensure due process and justice.
To respectfully disagree with my colleague, I believe that if one singular juror is set against whether it be the defendant or the conviction itself, or even being deliberately bribed by the prosecution, this is a violation of their due process rights, because it inherently prevents them from receiving a fair trial. If an instance like this occurs, the jurors are able to go up to the judge and express their concerns, and that can be addressed then instead hoping for a mistrial, which could eventually lead in there being double jeopardy.
Thank you. Nice job.
Nice job.
Give you the thumbs up emoji as the equivalent of a round of applause. So yeah, we'll give a little bit of feedback now. Yeah, so I thought you did a very nice job. Your prepared remarks, covered the ground well. The discussion of Ramos, I appreciated you got into the actual decision and the common law basis for it, which was nice. And I liked you highlighting kind of the discriminatory effects that were underlying the majority decision rules in Apodaca. So I thought that was good. I appreciated you kind of teeing up nullification as a concept. It was something I was planning to ask about, and I thought we had a good discussion there about kind of the double-edged sword. It's like most things, it's good when I agree with it, but it can be really bad when I don't. And how do you control that, or can you control that? And I'm not sure you can. And so I thought that was an interesting discussion as well. On the last question about jury secrecy, I wish we had more time to talk about that. I think the notion that the unanimity rule, bringing it back to that, is an insulation against the concerns, and that maybe the benefits of secrecy in the deliberations outweigh the concerns, because that somebody can't be convicted based on a biased, single biased juror. They can only be hung jury on a single biased juror. And so, the opportunity to retry them or to get another bite at the apple, maybe that solves the concern. So I thought that was an interesting concept. But overall, nice job. I enjoyed the conversation, and best of luck the rest of the day.
Thank you.
Thank you.